So if folks cannot attend, it will be posted on our YouTube channel, barring any technical difficulties. If you are a local government official, planning board member, zoning board member, or here for any kind of training credit, please make sure your full name is visible in the participant list so that we can record your attendance and make sure you are documented and get your training hours. And in the unlikely event of any technical difficulties, my presenters from Department of State are both co-hosts, so the meeting should be able to continue, and I will rejoin just as soon as I can in case I have any computer issues here in Rochester. I believe that's everything. So with that, I will turn it over to Chris and Trish from the Department of State. Thank you so much.
Okay, thank you, Jason, and good evening, everyone. Thanks for being with us. This is Zoning Board of Appeals overview, and we will be talking a little bit about the history of zoning, just a tiny bit. Modern zoning was first enacted in New York City just over 100 years ago in 1916, but the idea of regulating uses and design goes back to the Roman Empire and New Amsterdam, even before it was New York City. And I'm having a little trouble with with my screen. I'm trying to move the names out of the way, but I'll work on that when Trish takes over. This is one of our slides for our WebEx, and just an outline of the course. We're going to be defining the Zoning Board of Appeals and the enforcement official, of course, and the appellant, your applicant. We're going to be going through the interpretation process and the variance process, use variances and area variances. And then we'll wrap up with procedures, or toward the end of the course, we'll talk about some procedures that are similar for planning boards and even local governing boards. Some of these procedures apply to all boards. And then at the very end, we'll wrap up with the importance of findings and your decisions. So we'll start off by defining zoning. Zoning regulates use, density, and the placement of structures on a site. And of course, we'll talk about variances shortly, but there are variances. There's a use variance and an area variance, but not a density variance. The density is given relief depending on what kind of application it is, what kind of appeal it is. Density could be a use variance or an area variance. And of course, every municipality that has zoning has to have a zoning board of appeals. Zoning is optional though, and there are a number of towns in New York State and a few villages that don't have zoning, but all 62 cities do. And the result of dividing, the result of having different uses allowed in different districts and different dimensional requirements results in the division of the municipality into districts or zones, and that's where the term zoning comes in. And of course, the overall goal of zoning is to avoid incompatible uses. As I mentioned, all municipalities, all local governments with zoning must have a zoning board of appeals, and that zoning board of appeals is a buffer between aggrieved applicants and those applicants aggrieved by decisions by the enforcement official and state Supreme Court. So you've probably heard the term quasi-judicial body, which is what the Zoning Board of Appeals is. In some respects, the Zoning Board of Appeals itself is like a court. You look at your municipality zoning regulations, but you also have to function as decision makers. You're not just following that law, but you're considering what it means and appeals to it. And so your role is very important. And of course, the early zoning regulations had something like a zoning board of appeals, and an early challenge to zoning was in 1926. Euclid versus Ambler went to the U.S. Supreme Court, and zoning was upheld as a legitimate form of the police power. And that was a national, and we all learn about that case in planning school. But in New York State in 1925, the year before, the Oneida County Supreme Court ruled that the purpose of a board of appeals is not to destroy zoning, but to save it. And they went on further to say the property of citizens cannot and ought not be placed in a straitjacket. What might be reasonable today might not be reasonable tomorrow. So the Board of Appeals is to save zoning, and having that safety valve, as we sometimes call it, is an important component to zoning in general. Trish.
Okay, thank you, Chris. Hi, everyone. If you have zoning, then you have a zoning enforcement officer. And this is the person that is the administrative official charged with the enforcement of your zoning code as it is written. And they are the ones who render the first decision regarding the conformity of zoning. So someone's going to come to them and he makes, I'll say he for the sake of tonight, he makes the determination if the application or the project conforms with your existing zoning, and they cite any violation of the zoning code. It is important to know that the zoning enforcement officer is not the same person as the code enforcement officer. The code enforcement officer is charged with enforcing the New York State Uniform Fire Prevention and Building Code, completely separate. So although they're separate and distinct roles with different authorizations, different duties, different responsibilities, they even have different training. For example, the zoning enforcement officer isn't required to have any training at all, according to New York State statute. You may have something at the local level that wants this person to have training, but there's nothing at the state level, the way that you all have to have your 4 hours of mandatory training. So the code enforcement officer, they have to get at least 120 hours of training. So it's significantly more. So in some municipalities, the zoning enforcement officer can also wear the hat of the code enforcement officer, but it's important to remember that they are two distinct jobs. Even though somebody can have both jobs simultaneously, they are completely different, and they have different accountabilities and different training and everything else like that. So the zoning enforcement officer can be designated as your ZEO, or they can have the dual responsibilities along with your municipal planner, the code enforcement officer, or another person in your municipality. So if you're on the ZBA and you have some questions, you don't understand what a term is, or you're looking for an interpretation, do not go to the zoning enforcement officer. You should be directing your questions to your municipal attorney or to your planning staff if you have them, or your county, or you can certainly contact us at the Department of State. We have professional planners and attorneys at your disposal, but just keep in mind, if you have questions, do not go to the zoning enforcement officer. You need to go to someone else. Next slide, please. Chris, next slide, please. Thank you. So the statutory authority for zoning is laid out here. All the power for a municipality to enact zoning comes from the New York State Constitution. All zoning comes from the state. And it also includes the authority to create the Zoning Board of Appeals. And once your municipality, your local governing board has created the Zoning Board of Appeals, then that local governing board is no longer involved with any decisions that you make. They can't tell you what to do or how to do it. You are quasi-judicial and you are independent from the local governing board. So this little chart here shows what your membership is, your procedures for your zoning, and the procedures and the statutory test for variances. We have a book online, a publication online called The Guide to Planning and Zoning. It's divided into 3 parts: village law, town law, and general city law. I recommend that you all get this publication. It's in PDF format or just a link on our website. And it's kind of the shortcut. Everything that you need as a zoning board member or a planning board member is listed there in layman's terms. So if you go to Town Law 267, you just open up that 1/3 of the book dedicated to town law, and it spells it out, you know, what your membership is, and it's just very simple. It's a good reference material. If you need to look up state laws online, you can go to this statutes online at publeginfo.state. I usually just don't type that in. I usually just go to a search engine and type in leg info and, you know, follow the links from there. So those are some good tips to keep in mind for reference materials. Next slide, please. And because you are a zoning board of appeals member, you are also a public officer. You are held to the standards of a public officer and ethics and all of that other good stuff. So let's go over your terms of office. You either have a 3-year term or a 5-year term. And that term is based upon how many members you have. If you are a board consisting of 3 members, then you each serve a 3-year term. If you're 5 people on your board, then you each serve a 5-year term. And your terms are staggered so that you don't have a brand new board starting fresh, a freshman year board, all at once. So we need to have that institutional knowledge carried over from year to year. So that's why you have the staggered terms. It's also a good idea to have staggered terms or terms because you don't necessarily, you know, when a new administration comes in, you don't necessarily want that new administration to stack the board with all of their favorite people. So you need some balance there as well. So your qualifications for membership on the ZBA are age. You have to be at least 18 years old. You have to be a citizen of the United States, and you have to be a resident of the municipality in which you serve. There are very few exceptions to that residency, but generally speaking, you need to be a resident of the municipality in which you serve. So there are times when you can be removed. We like to say, if you can be appointed, then you can be disappointed. If we were in person, we'd be laughing, hopefully, because that was just a little joke. But anyways,
I'm laughing.
Oh, thank you. You can be removed from public service, but you have to have a public hearing. So it's not like your appointing authorities or your mayor or your supervisor can't tap you on the shoulder one day and say, hey, bud, don't come anymore. You're all washed up. Or we don't like the way you're voting. You can be replaced. It's not that easy. I've heard that it happens like that, but it shouldn't happen like that. And you can be removed. It's helpful if you have your rules and responsibilities spelled out ahead of time, board procedures that have been adopted so that you have standards. And if you're going to be removing somebody, then you have to hold them accountable to a standard that they are aware of and that's written down somewhere. And some cases of removal could be attendance. So failure to attend 3 consecutive meetings, or failure to attend, any number of meetings. And the word cause. Cause is one of those inexact legal terms of art. If you're going to be removed from cause, it helps to have that cause specifically identified. It just makes it easier for the appointing authority to remove you, and it makes it easier for the board member to defend themselves if they know what that cause is. Over here in this box, we have the oath. As public officers, you have to sign your oath when you are appointed within 30 days of your appointment. It says, I do so solemnly swear or affirm, blah, blah, blah. If you fail to sign your oath of office within those 30 days, like, you can't go rushing in there tomorrow and sign the book if you're 30 days up. To formally cure that, you have to be reappointed and then go in and sign your book. Otherwise, your seat could be considered vacant and someone else could be appointed. There is something known as a holdover. A holdover is when you've been serving and your term is up, and maybe nobody says anything to you. Maybe there's no one waiting in the wings to take your seat. So you are still a member with all of your rights and responsibilities. You can still vote. Everything remains the same if you are a holdover. All of your actions, your voting actions, are still valid. One last thing to talk about on this slide is alternates. Alternates may be appointed in the same manner as you were appointed and by the same appointing authority. The difference is New York State statutes allow for alternates to serve when you have a conflict of interest. If you want an alternate for any other purpose, then you have to go above and beyond the New York State law and state the reason for that. But the law only provides alternates for a conflict of interest. So, for example, if you needed to call in the alternates because you could not achieve a quorum, that would be a different kind of law that you would have to supersede the statute and adopt a new law allowing for alternates for that purpose. If you are an alternate, it's a good idea that you familiarize yourself with the record and go, publicly in your meeting minutes, state that you've familiarized yourself with the record and that you feel confident to take action or vote on the application. That's just considered a good business to do that. That's not mandatory to do that, but it's just good if you're ever challenged in the future. At least the judge and people will look at that and say, well, they knew what they were doing when they came in and took the vote. So next slide, please. Training requirements. So that's the reason you're all here today. New York State planning boards and zoning boards of appeal have to take at least 4 hours of training every year. The good news is that if you achieve more than 4 hours, then those excess hours may be carried over, and there's no limit to how many hours you can collect. And the bad news is you cannot share your excess hours with your fellow board members who failed to achieve that training. If you fail to comply, what happens if you don't achieve your training? You get 3 hours, or you didn't bother to get any hours at all. Unfortunately, it doesn't void any decision that you have made. You can still vote on applications. The consequence is that you are ineligible to be reappointed when the time comes for your reappointment. You have to ask yourself, of the 9,000 hours in a year, why can't somebody carve out 4 when they are really doing such important work for their community? It only makes sense that you would want to stay current with changes in law and planning philosophies. So it may seem tedious or onerous to get your training, but when you consider it's only 4 hours out of 9,000 in years, maybe that's not so horrible, hopefully. And the governing board approves and tracks your training. So your municipal clerk, your village clerk, or your town clerk, they are the folks that keep track of your hours. At the Department of State, we don't do that. So it's the honor system. We do track the hours for the building code officer. As I mentioned, they have to get well over 120 hours of training, and there's a whole department dedicated to their training and tracking of their numbers. And your training comes in a variety of sources and formats. We try to make it super easy for you to achieve your training each year. You can get it from the New York Conference of Mayors, Cornell Cooperative Extension, DEC. We have webinars. We have interactive training on our website. Soon we'll be on the road again, I'm sure, probably next year. I can't say positively, but I'm sure we'll be back out there in person. Even if you wanted to have, read a book or have somebody come in and teach you how to read a blueprint or a mapping or anything. If your local board says this is the kind of training that we want and your board approves it, then that's fine. And that can pass for your credits. And this bottom bullet here, requirements may be waived or modified by resolution if it's in the best interest of your municipality. Believe it or not, there are still places that have waived the training requirement. The training requirement is not in the best interest of a municipality to waive it unless they have people serving on the board who are already getting their training, maybe from a different profession. They have to have continuing education credits, like a lawyer or an architect or an urban planner, a profession where people have to keep up their credits constantly to keep their license or their degree. So it may be redundant for those folks to sit through a training like this. So in that case, yeah, go ahead and waive it. On the other hand, your municipality may say 4 credits isn't enough. We want you to have 5, or we want you to have 10 credits. So bear that in mind if you think 4 is too much of a struggle. So next slide. All right, so the ZBA has different roles in different municipalities, but what they do have in common is they all have appellate jurisdiction. And that word appellate, it means that applications are coming for the purpose of being reviewed so that they can be reversed. And all ZBAs have appellate jurisdiction. They can interpret the zoning regulations and they can issue permits or issue variances or deny variances. And some ZBAs have original jurisdiction. Original jurisdiction means that applications come to them first. So this only happens when the governing board has delegated that authority to them beforehand. So in the case of site plan review or a special use permit, they don't have to wait for another determination to happen first. These applications would go directly to the ZBA for their immediate review. In the case of subdivision, this is a little different. New York State statutes specify that the planning board will perform subdivision review. The ZBA would not, I want to say will never or will rarely conduct a subdivision review. That is spelled out in New York State statute that the planning board should be doing that. So next slide. Thanks.
And this is mine. So back to me. Appeals. Trish talked about the appellate jurisdiction versus the original jurisdiction. Appeals for interpretations or variances, the zoning enforcement official must have acted to get for the appellant to get to the zoning board of appeals. So for the most part, in almost every case, the enforcement official has to act by either granting a permit, denying a permit, or issuing a citation for a violation, or taking another enforcement action. The exception to that rule, so you can't just go to the zoning board of appeals. You can't just say, I want a variance. You have to have a denial first. And the exception to that rule is what we call the direct appeal. But if you do a search for direct appeal in the Guide to Planning and Zoning Laws of New York State, that compilation Trish talked about of statutes that pertain to planning and zoning in New York State, you won't find the term direct appeal. The process of a direct appeal is described in the section of statute of town law, village law, and general city law that deals, and they're nearly identical in each form of government, these anyway, the site plan review, subdivision review, and special use permit sections of statute. They both include the ability, if the applicant property has a deficiency of frontage or needs relief for lot coverage or from setbacks, that there is the ability to go directly to the zoning board of appeals while in the process of, after the preliminary site plan review or review of the preliminary plat for subdivision, for example. The planning board can send those applications to the zoning board of appeals before final approval without the enforcement official having to deny the application. So it's a little bit of efficiency built into the system. And some zoning regulations require referral by the planning board that the zoning board of appeals can adhere to or not. But ultimately, that appeal, that relief is up to the zoning board of appeals, the amount of relief granted. And of course, we'll talk more about that shortly. The appellant, the applicant, must have standing. And what that means is the property owner who's denied a permit or cited for a violation has standing to go to the zoning board of appeals. Or a third party, like a neighbor, for example, who stands to be harmed by the enforcement official's decision. And right in statute, town law 267 and the equivalents is the municipal officer, department, bureau, or board. A municipal officer, department, bureau, or board could bring the appeal to the zoning board of appeals if one of those entities disagrees with the enforcement official's decision about an application. Now, usually these applications that we're talking about at this point are the applications that an enforcement official is responsible for. So it's a building permit, for example, or a zoning permit, as some municipalities have, and that the individual denied a permit or cited for a violation, or the third party, the neighbor who wants to challenge a decision by the enforcement official, or the department, officer, bureau, or board, which is the rarest instance of an appeal to the zoning board of appeals. It's not very frequently that we hear about municipal officials or other boards appealing to the ZBA, but the time frame is 60 days. So if you're denied a permit, you have 60 days to appeal it. And the exception to that rule is that third parties' neighbors have 60 days from the date they could have knowledge of the enforcement official's decision. So that means because it's just a permit and not a public hearing, and you wouldn't necessarily have notice of an application, you might not know that there is an application that was approved. So for example, if I live in the house on the left, the clapboard house on the left, and Trish lives in the brick house on the right, and Trish has started, she's gotten a permit in January to build her garage, and she poured the footing right after the snow melted in April, let's say. And so I didn't know about that action until April. So I have 60 days from the time I could have known that Trish was working on a garage that's awfully close to my property line, right? And so I have 60 days from the time I could have known. But if I take a trip and I'm not back home until the garage is at this stage in May or June, let's say June, because I might have known in April, but June or July, the 62 days has elapsed, and I'm out of luck. But let's say I do get to the enforcement official early enough, and I call the building department and I say, Trish is building a garage that's really close to my property line. And can you measure? I have a survey here. Can you take these measurements? I think, if anything, she needs some relief in the form of an area variance, which again we'll be talking about in great depth in a few minutes. And Trish says, "Oh yeah, I need to appeal to the Zoning Board of Appeals. I guess I am a little close." Once she files that appeal, she can continue. That stays enforcement. The enforcement official finding that the garage was too close to the property line and Trish needed some relief, she needed an area variance, he might have put a stop work order on it. But in law, it's kind of a funny thing, but it's right in statute. The appeal stays the enforcement. So once Trish files for an appeals to the ZBA for an area variance, she can continue building, but it's at her own risk, because that Zoning Board of Appeals, sometimes you're all probably familiar with the applicants who ask for forgiveness rather than permission. But there is case law that says that a building built illegally, if the Zoning Board of Appeals denies the relief, or certainly if it were over on the other side of her property line, if it were over the property line, the Zoning Board of Appeals could deny the variance in order that the garage, the structure, be moved. So that's something that you should all know. Obviously, the most expedient thing to do is to maybe add a condition to the after the fact variance, but keep in mind that once there's an appeal filed, enforcement is stayed.
Chris, this is Jason here.
Hi, Jason.
We have a couple questions in the chat room. I
Sure.
thought maybe it's a good time point. to ask them. Larry asked, shouldn't the ZEO have taken the measurements before issuing a permit?
Yes, of course. And maybe the ZEO did take measurements and the homeowner didn't follow them exactly. But
right.
Yes, of course.
Yeah, and I've worked for municipalities, and I've been in that position of where, the drawing says one thing, but the homeowner does not follow what the drawing says, and all kinds of situations there. We had another question from a little while ago. Randy asked, can this is interesting, and I think I know the answer, but I'm not sure. Can attendance at a ZBA meeting as an alternate member be considered training?
Well, if the local governing board believes it should count, it could count, then yes, but that would maybe only go so far. It wouldn't really make sense to require to count attendance at board meetings training, because if that were the case, regular board members wouldn't need training because they are at their board meetings all the time.
Right.
But maybe an hour or two of training, an hour or two of attendance at a board meeting for an alternate makes some sense. So, but ultimately it's up to the local governing board.
Good. Yeah. Thank you. And then finally, earlier on, I think maybe Trish was talking about terms. So a 7-member board would then have 7-year terms for its members?
That's correct. And yes, those are long terms, and it is possible for the local governing board to supersede statute and reduce those memberships to a smaller number of years. But that's unusual. Most the way the statute reads makes a lot of sense because it's one seat turning over every year. And of course, when the statutes were updated in 1994, there had been, I think, a zoning board of appeals in our current statutes can be 3 or 5 members. So 7-member boards are that's a leftover from 27 years ago or more. And although some boards really feel that it's best to have a larger membership, and the advantages to that is it's easier to get a quorum, and the greater number of members on the board, the greater the collective brain trust. So, but that's correct.
And then finally, one last one that just came in, and then we'll move on. Does the ZBA normally do site plan review rather than the planning board? And I guess I'll partially answer. In my experience, it's almost always the planning board that does site plan review and not the ZBA.
Thank you. I don't even know why we still have that in this course. I think I might do a little editing because site plan review, I don't know of a single zoning board of appeals that does site plan review. And I think years ago, the zoning board of appeals did special use permits, reviewed special use permits more often than they do today. But that's something I think the trend is, I think in the 60s, 70s, even 80s, and there's still boards out there. There's still zoning boards of appeals out there that do special use permits, that review and grant special use permits. But I think the trend has been more for planning boards to issue special use permits and of course do site plan reviews. So we talk about zoning boards of appeals being able to do site plan review like it's common, but it's very rare if it happens.
Well, I guess if you're one of the relatively rare communities that has a joint ZBA planning board, that's one body, that body would then do site plan review, but those are pretty rare. So
you're right about that, and we do get those questions every now and then. And the answer, if you want to dissolve your planning board and just have one land use board, as some municipalities call them, the way to do that would be to abolish the planning board and have the zoning board of appeals supersede statute, to have give subdivision to the local governing board and give special use permit and site plan review to the zoning board of appeals, and then you'd only have the zoning board of appeals. But that's not recommended.
Yeah,
we certainly, there's a reason there are 2 boards to share that responsibility of administering zoning regulations and the balance of power and authority. And we've heard from boards that have dissolved, local governments that have dissolved their planning boards, and then after a few years reestablished them. In some cases, the local governing board, the town board or village board of trustees, takes the responsibility of the planning board. And those arrangements usually don't last very long. And for those having trouble finding members to serve, there is the option, of course, to have a 3-member zoning board of appeals, the joint village town planning board and zoning board of appeals. So having 2 members from a village, 3 members from a town on a planning board, and 2 members from a village, 3 members from those same village and towns on a zoning board of appeals. That's another model that is one that works fairly well. And finally, our audiences on this webinar are probably not from really rural areas like the Southern Tier and North Country, but in the Tug Hill region, there are 2 cooperative zoning boards of appeals in very rural towns where the zoning board of appeals isn't very busy. And there are 5 towns, and 1 member from each town is on the cooperative zoning board of appeals. So that works really well too.
That was actually, you anticipated my next question. I was going to ask that, because there are parts of our region, especially heading down south into the Southern Tier, southern Wyoming, Yates County, southern Livingston, where the towns are quite small in population, where that would be an option for them, I think, if they're struggling to get members. So certainly good to know all the tools available there. So without further ado, please continue with your presentation.
Thanks for the questions, Jason. Trish, on to you.
Okay, thank you. So now we're on to interpretations, and the Zoning Board of Appeal can grant 2 types of relief. That can either be in the form of interpretation, or it can take the shape of variances, either a use variance or an area variance. In either case, the ZBA will affirm, reverse, or modify the zoning enforcement officer's decision. And the basis for decisions always comes from the existing zoning. So whenever you're reviewing applications, you should have your zoning code out, you should have your comprehensive plan out, and review these applications against your existing documents. And it shouldn't be reviewed against what you like or what you think it should be. You have to compare these things against your existing documents. So next slide, please. An appeal for interpretation. This is one of the most common things that causes someone to come before your board. This happens when the applicant believes that the zoning enforcement officer incorrectly applied the law. So how does that happen? They might think that there was an incorrect definition, or they didn't like the way that the zoning enforcement officer took their measurements. So one of the terrible things that you can have in your zoning code is the phrase "or similar use." I hope by now that it is eliminated from everybody's zoning. If you have a phrase like "or similar use" in your code, that tells an applicant, well, we don't know what it is, and you don't know what it is. It's almost begging for an excuse to come before the board for an interpretation. So it's too broad, and you should be using very clear definitions so that, cut down on the request for interpretation. For example, some zoning codes will say just a broad category like restaurant, comma, or similar use. So does that mean a cafe, a tavern? We know of one city that didn't have a definition for a hot dog cart, a street vending food cart. And so it had to fall under the category of restaurant, even though there was no seating in, or no service. It was just an outdoor transitory kind of thing. But if you have "or similar use," these are the kind of things that's going to happen. Another common definition that comes for an interpretation is it a deck or is it a dock? Well, these might not seem like important things to you, but for certain applicants, they may have different setback requirements for decks versus docks. And, it just may open up a host of other reviews. Maybe you're going to need the Army Corps of Engineers, and maybe you'll need a DEC permit. And there's all kinds of reasons why you would want to have very specific definitions to prevent this kind of thing. Sometimes you'll have a request for measurements. Maybe maybe the applicant didn't like the way somebody measured. Was it measured from the front door or was it measured from the property line? Again, maybe you don't think this is a very big thing, but if you are trying to apply for something, a use that has to be within 500 feet of another use, then you can see where this numbers game could really impact your application sailing through or having to stop and ask for an variance. So we're going to take a look at a few more of these. Next slide, please. And the basis for the interpretation for the decision should be on the past decision that the board has made, if on a very similar application or something to do with the same regulations or very similar facts. So the board should look to its past decisions before they're reaching a different result on essentially the same facts. Otherwise, it could be reviewed, it could be viewed as an arbitrary and capricious decision. However, a board is not bound by past decisions and may correct their errors. So as Chris mentioned in the beginning, times change. So are you bound to a decision that you made 35 years ago when that land use, isn't there? We don't have a lot of land uses anymore, and we have new land uses. So we shouldn't be bound to the past, although you need to make sure that you're not being arbitrary and capricious. If you are reviewing a similar application, but the environment has changed, the facts have changed, you should note that in your decision so that if you ever are challenged, it will be clear that you made your decision on a sound, rational basis. So you can look to definitions from the Planner's Dictionary. You can get land use definitions from your local assessor. They have definitions on architectural types, on property types, on land uses. There's all kinds of places where you can go to find good definitions. But like I said, if you are getting a lot of these kinds of requests, it's a red flag that your zoning is out of date and your comprehensive plan needs an update as well. You can also base your interpretation on past meeting minutes, any comments that you've collected during the hearings, and the ordinary meaning of terms if the term is undefined. So next slide, please. Here's an example of the ordinary term. Now, in this upper picture, this is the Albany Armory. It's on the opposite corner from where our building is in Albany. And it's a sports arena, but they also have concerts and entertainment type things going on in there. In 2012, they were having raves. So there's a picture of a rave in the bottom picture. It's a bunch of people standing up close together dancing. As you can see, there are no seats involved. It's pretty much a standing situation. So in this application, somebody applied to have a rave activity here at the Albany Armory Sports Convention Center, whatever they were calling it at the time. And they referred to the use, the Albany BZA. That's not a typo. It's called the Board of Zoning Appeals when you're in Albany. And they denied this application because they said, we have an auditoria or auditorium they referred to that in their defense of this application. But nowhere in the Albany zoning did they actually define the word auditoria or auditorium. So they went to the dictionary and they finally found a definition that they liked. They relied on that dictionary definition, the one that included, quote, where the audience sits, end quote. So they stopped there. They stopped when they found the definition that suited them the best, even though there were other definitions easily available that included a reference to fixed seating or seating somewhere in the definition of an auditorium. So the rave itself did not provide for fixed seating in their application, so they denied their application. However, they lost because the court concluded that basing their decision solely on one limited definition to the exclusion of all other commonly accepted ones was irrational and unreasonable. So the lesson here is, if you're going to refer to a word in your zoning, then make sure that it is defined in your zoning, and make sure it has a common definition and not, one that most people would associate with it, and not a narrowly defined one.
I think there was a little more to it, Trish. That's most of it. But what actually happened was they stopped. Like if they had if they had read on in the possibilities and definitions, I think whatever dictionary they used, the first number one was a place where there's fixed seating for auditorium. Number two was it could be a place where people stand. But the point here to really remember is, and first off, the Supreme Court, state Supreme Court, agreed with the BZA and backed them up. It was when the owner appealed and went to the appellate division that the appellate division ruled against the city. And one of the reasons this was a problem, and we'll talk more about this later, of course, was that there had been a lot of use variances granted to this building over the years because it's something of a white elephant. And if the city had just refined its definition, if the city had changed the zoning on this building, on this property, and said, oh gosh, these rave concerts are a bit much. They are so crowded and it's over capacity for this building and we really need to rein it in a little bit. They could have written their own definition. So I believe that was a part of it too. So just wanted to add that.
Well, thank you for clarifying that.
Sure.
And do they even have concerts at all there anymore, or what's going on?
I think somehow, even though they lost this one, I believe because it's very close to a residential neighborhood. It's in a commercial area, but it's close to residential neighborhoods. And so the impact of shows getting out really late, and I don't think the residents of the nearby neighborhood really love that LED sign that you see in the foreground either. But I believe they scaled it back. Ultimately, there was some agreement reached. But it's an interesting case for a number of reasons. The definition component, and I wouldn't have known, but for having given this course in the Capital District, and somebody from a member, I think at the time chair of the City of Albany Board of Zoning Appeals, raised his hand and he said, oh, there's more to that story. We would have been able to change the definition to our liking had it not been granted, had this property not have been granted, had it not been granted many use variances over the years. So beware of use variances. More about that in a few minutes, but we'll move on to the next slide.
Okay, well, the next one, talk about residential uses. This one has to do with a commercial use in a residential district or neighboring a residential district. So This one, Cupid's Video Boutique versus the Town of Babylon. This one had to do with taking measurements. So adult uses are protected as part of freedom of speech in the Constitution. So you have to allow them somewhere in your municipality. After that, it's up to you. You can have them all in one corner or you can sprinkle them throughout, but you have to have a viable place for them someplace. And it gets a little tricky because in this case, it was a minimum of a 500-foot radius from a residential area for adult uses. So where do you start to take that measurement? Do you take it from the property line or do you take it from the front door? So here the Town of Babylon's code said that they didn't want any of these adult uses within 500 feet of a residential area. And the measurement was taken from the front door, but there's no express statutory language requiring measurements be taken in a straight line from the center of the nearest entrance. And in this case, the board got some deference. Their decision was not irrational, unreasonable, or inconsistent with the legitimate purpose of their zoning ordinance. So they were allowed deference in their decision, and their 500-foot radius had to do with the entire parcel, not just the front door. And when you are reviewing applications for adult uses, like I said, you have to allow them someplace in your zoning code, but you really should aim your regulations at the secondary effects of adult uses. And presumably that could be loitering, maybe prostitution or drug use, you name it, all kinds of things that you might expect to be happening in back or in the parking lot or out front. So there's a little tip for you on adult uses. And next case, please. Next slide, Chris. So now we're going to do use variances, and this is Chris is going to take these for you.
Thanks, Trish. So with a variance, Trish reviewed how interpretations occur. Owners appeal for interpretations when they disagree with the enforcement officials' read of the zoning regulations. And when they apply for use variances, they appeal for use and area variances when they agree with the interpretation, but feel that they need some, that they deserve some relief from the zoning regulations. And the use variance is appealed for when the applicant needs to use the land for a purpose not permitted by zoning. And when this is Central Avenue in Albany, the photo that you're looking at, the car wash in the middle of what was a residential neighborhood. And there are a few commercial uses farther west to the right of the frame here. But I often wonder, how did a car wash ever end up there? Was it probably something was there before zoning and it wasn't granted a use variance, because you can see these houses are inhabitable and they're inhabited, and it probably, if it was granted a use variance, it wasn't done legally. And even if it is legal, there is always the alternative to rezone the property. And we have a course called Spot Zone or Grant the Illegal Use Variance that I came up with, where I just looked, because there are a lot of boards that are afraid of spot zoning. Local governing boards are afraid of changing the zoning, but you're only spot zoning when you change the zoning for the benefit of one or a few property owners and to the detriment of everyone else. The use variance, if you don't grant a use variance as a zoning board of appeals, it's not because you're being mean, it's because you're following the law. The law is, the use variance test is very strict, and it's strict for a reason. Because if you as the zoning board of appeals, unelected officials, appointed officials, are granting a use variance without following this very strict 4-factor test, you're basically changing the zoning and don't have the authority to do that. So the burden of proof for a use variance is on the applicant. You have the upper hand to deny the request for a use variance. And we'll go through these 4 factors in some detail on these next slides. The first one is really the toughest. The applicant must demonstrate that the land, not the applicant with the current use, the land is not capable of making a reasonable return with any of the permitted uses, any current lawful non-conforming use, and any use that was permitted by a previous use variance. And the zoning board of appeals must consider the property as a whole, not just the building that might be in a corner of the property, and that little section alone, but the entire parcel. So that's a really difficult test to pass. That's a very difficult factor to move beyond. And there are no hard and fast numbers. That's why there's not one member of the zoning board of appeals. That's why you can't have the enforcement official review, consider use variances. That's why you have a board for this job. The circumstances, whether the use variance is granted or not, or whether the appellant passes this first factor of the test, depends on the facts of the application. And it's up to the zoning board of appeals, who don't have to agree with the expert's opinion. And in this case, this case is referred to in other cases about use variances. The applicant, Petrozzulli, had a parcel in an area zoned single family and wanted to build a multifamily house. And the argument was that she could earn more money by building. She could rent out a bunch of apartments or sell the parcel for more if it were a multi-unit building. And the zoning board of appeals said, yeah, you will make more money if you build the multi-unit dwelling, but that does not entitle you to the use variance. And many courts have the refrain that applicants, property owners, are entitled to a reasonable, but not necessarily the most profitable return. So that you hold a lot of, the law is in your favor here to deny those use variances. You have the upper hand, zoning board of appeals members. The second factor is unique circumstances. The parcel has to be one of only a very few that's affected by the zoning constraints. And it's the uniqueness of the land causing the hardship, not the uniqueness of the hardship of the owner. So this is kind of a silly photo just for kicks, but think about the possibility of a building like a former school building that is in a residential neighborhood. It's no longer a school. For whatever reason, the city council or village board has not changed the zoning on that building. Somebody bought it years ago before zoning was enacted and has been trying to do something with it. And now it's single family residential. Well, you can't feasibly make single family residential out of a former school. And former schools are really good uses for multifamily residential or senior housing. And so if the local governing board does not rezone that parcel, then which is the ideal, because you can adjust zoning, but once you grant the use variance, it's very hard to take it back, almost impossible to take it back. And the third factor is self-created hardship. Is that hardship self-created? If it is, then you are not eligible, or the property owner is not eligible for that use variance. So this space, the empty space you see in the bottom photo, is just up the street from our office, and it used to be a bank. There were every other building in the city of Albany used to be a bank, it seems, and they are going away very rapidly. And so this space, let's say it was zoned for offices and not for restaurants, for example, and the Trish owned the building, and I wanted to move in to operate a restaurant. If I bought the building, let's say I buy the building and I want to put my restaurant in that storefront space. If I've bought that restaurant, even if I didn't know that, or if I've bought that building with aspirations for a restaurant, even if I didn't know that only offices were allowed in that storefront, only offices and certain types of retail, certain retail service was allowed there, but not restaurants, I couldn't claim that I had a hardship because I created my hardship by having bought the building. And maybe not the best example, but once you buy the building, once you buy the property, even if you don't know the zoning, you're bound by them. That's the second bullet here. Owner is bound by zoning restrictions, even without knowledge of them. And spending money on a project not allowed by zoning does not entitle you. You can't say, well, we've spent thousands of dollars on this, we're underwater. Well, the owner spent the $1,000 not knowing, or maybe banking on the use variance, and that's not counted in the hardship. Now, if Trish owned the building and said, banks are moving out, we need more restaurants in this neighborhood, having a restaurant here wouldn't have a terrible impact on the neighborhood. Of course, if she went to the local governing board, they could rezone it, but even if she went to the zoning board of appeals, being the owner at the time of the zoning, Trish could appeal for the use variance and can avoid, she would pass the self-created hardship test because she owned the building at the time of the change in zoning. And I would be the contract vendee. I could apply on her behalf as a potential owner, but once I buy it, and it's a self-created hardship. So I hope everybody understands that there's some subtleties there, and it always seems harder to explain by webinar than it is in person. And the fourth factor, if you get through all these, is neighborhood character. And is the proposed use consistent with the surroundings? Now, we use this example because of the laundromat on the right, and yeah, that's if I believe the big Victorian house on the left is not a single family home anymore. I think it's offices and a couple apartments. So that laundromat does kind of fit in because it's a good place for people to do their laundry, but it doesn't fit with the character in the sense that the parking's in the front, the building's set back, there's no landscaping around it, it's one story, it doesn't fit with the neighborhood. If that were another building or a vacant lot and somebody wanted to build a multi-unit residence and in a neighborhood that allowed, let's say, single-family residences or two-family residences, and somebody wanted to build a 4-unit. This does happen to be at the intersection, I believe, of 2 state highways in the village of Ballston Spa. So if the building could be designed to fit into the surroundings and it to another residential use, for example, or a building that fit more with the context of the neighborhood, with the maybe laundromat and a small storefront and the and residences above, that might be a more acceptable use of that parcel, and it would fit more with neighborhood character than what you see here. But once you get to the neighborhood character factor, you're really, the zoning board of appeals is getting can be creative. But you ask, would there be a significant adverse impact on the neighborhood? And that is if the use variance were granted. And certainly in that first example with the car wash, the answer would probably be yes. So it's just an unusual situation that car wash is even there among those 2-family houses in that first photo that I shared with you. So I see that there are a few questions. Jason.
Yeah, I was going to say, Larry has a question on self-created hardship, which I know that's something I've been doing this for well over a decade and I still struggle with it. So maybe we could go back to that slide.
Sure.
And, Larry, if you want to unmute yourself and ask the question, hopefully we can help with that.
I'm here. Can you hear me?
Yes, sir.
Yes, Larry.
Okay,
I'm glad you made it.
Yeah, me too. Thank you. You said that if the new guy wanted to buy it and the zoning was already in place, then that is a self-created hardship. And you said that if Trish tried to change the zoning before she sold it, then she would be allowed to do that because it wasn't a self-created hardship. Are we assuming here that the zoning was changed or put into place after Trish already owned the building?
Yes.
Okay, then that makes sense. Okay,
Yes.
that's it. Thank you.
So Trish owned the building, Trish bought the building, the zoning changed, they got more restrictive,
Right.
and then she said, oh, I need some relief.
Yeah,
And
that makes sense.
Yeah,
That makes sense.
good,
Okay,
good.
thank you.
Great, you're welcome.
So
Anything?
we have another question
Sure.
from Randy, and this is a good question. I'm going to give my answer, having done this for a couple different municipalities,
Great.
and then feel free to chime in.
Of
How does
course.
zoning transition along a street from residential to commercial? And it's a good question because you have to draw the line somewhere, right? And so it's always sometime it's a tough call on where the boundary between 2 different districts exists. The one piece of advice that comes to mind immediately is you can craft your code excuse me, to address those boundary lines. So I know with some of the municipalities I worked for, the zoning code would include things, like in a commercial district, the setback is X, but if it is abutting a residential district, the setback is Y. So you can calibrate your code depending on whether it's a boundary line parcel or not. So so that's my thought initially. Chris or Trish, feel free to weigh in on that question on transition.
That's a good one, Jason. And I would just say that usually there might be, if you have just the traditional neighborhood design would have on a main street. And I found myself in Binghamton a few months ago, earlier this year, and I had a bit of a problem with my car. And so I brought the car into the shop and I took a walk and I saw how elegantly the traditional neighborhood design there was. I was in a neighborhood where there was a mix of commercial and multi-unit residential and really beautiful early 20th century apartment buildings. And then on the side streets, there were 2-family houses on the first block and then single-family houses on the second block back from that main street. So you could really see it was a natural a natural transit-oriented development corridor. This is probably the old Route 17 coming west out of Binghamton. And I don't know what they call, what the state route designation on that street is now, or the street name even, but it's a major corridor that goes to Johnson City and Endicott from Binghamton. But yeah, that's the kind of transition, maybe with single family to multifamily, to a mix of uses with retail on the first floor and apartments above, and then and that's in a more traditional environment. There might be, you might want to have more of a buffer for those kinds of highway uses that I guess we need to have, but there's not a really easy place to put them.
Yeah, no, that's a great example.
Yeah.
That works well, I think, in like a city or a larger village or a town where you have sort of more real estate to work with. But if you're in a smaller community, another thought I had, and this is borrowed again from Rochester, but where, if you're on one of those mixed use sort of Main Street type areas, you can vary the height. So maybe you could have up to a 5-story building along the front of the parcel, but the rear setback would include a height, a sort of step down as you approach the residential neighborhood. So maybe the back of the building can only be 3 stories tall to better transition to like a neighborhood of the house in the picture here, and work the transitions that way in sort of a tighter area. But it depends on what type of community. If you're more car oriented, suburban or village, and more traditional, like Chris is talking about, there's different ways to do it, but hopefully that helps.
Thanks, Jason. Yeah, good discussion here. So a little bit of planning and Zoning Board of Appeals overview. And we were talking, speaking of uses that existed before zoning was passed, these are a couple that might have. The body shop, not too far from that car wash as it happens. And maybe one of those uses, you can see that the place next door is residential. You might not want a body shop right next door to residential, and a bar in the middle of a residential district. And I think from what I know, this bar isn't really a problem in that residential district, at least as far as I know. And I don't know about the body shop either, but these uses were probably legal at the time they were established. And when zoning came in, they were, as so many people say, grandfathered. And Jason once told me not too long ago when we presented this course that the term grandfathering is not a good one to use, and it has its origins. It has racist origins. I didn't like the term even before I learned that, but we still leave it in here because so many people use it. And they say, if not local officials, applicants, they say, well, isn't this use grandfathered? And they think if it's grandfathered, it's sacrosanct and it can never change. Well, pre-existing legal non-conforming uses may remain, but in order to expand, they need a use variance. If that body shop wanted to expand, if they wanted to build an addition, or that bar wanted to have an outdoor concert venue in the backyard, for example, they would need a use variance for that. To expand, to change in any way, they need, except to become less non-conforming somehow, they would need a use variance. And if they, having that pre-existing legal non-conforming status is not necessarily forever. If the local government, and not many do this because it's kind of politically challenging, and then even when they pass the law, sometimes they don't have the will to enforce it, but it's possible to phase out through amortization the pre-existing legal non-conforming use. When the zoning changes, because if you couldn't do this, what would be the point of zoning and changing zoning? You'd be stuck with these uses forever. Well, except for abandonment, you see in the parentheses on the fourth point, uses can, if there were a fire or a flood, or at either of these uses, and they were more than 50% destroyed, the zoning might say if it's more than 50% destroyed, then it phases out. Or if it's abandoned, if the bar is closed for more than 6 months or a year, that's abandonment of the pre-existing legal non-conforming use status. But the municipality, even lacking any of that, abandonment or destruction, the local government has the ability to amortize out pre-existing non-conforming uses, and should do so over a long period of time, in order, like years, 5 or 10 years, for example, in order to get and there might be an appraisal of the property, and your municipal attorney would of course be involved in this process. And but it is possible to allow the owner to recuperate the investment and then sell the property as an allowed use. So I will turn the mic back to Trish, who will talk about area variances.
Okay, thank you, Chris. So the area variance test is a lot easier than the use variance test. It is a 5-prong test that is also set forth in New York State statute that you have to follow when you are reviewing a request for dimensional relief. So next slide, please. Thank you. So the area variance, as I said, you are asking, or the applicant is asking, for dimensional relief from the existing zoning regulations. And for example, in this picture, the property needs a variance for the setback requirements to have a driveway, because this driveway is too close to the lot line. And it also has a drive-through, and it's got a wooden fence, a chain link fence, and an array of some trees as well. So just a simple example where the applicant needs some dimensional relief. Maybe they need 2 or 3 more feet to construct their fence so that they can have a driveway that is secure and private. So next slide, please. So the area variance test is a 5-prong test, and the goal here is really to balance the health, safety, and general welfare of the community against what the owner or the applicant is looking to achieve. So it's really the owner versus the municipality, the benefit versus the burden that the municipality is going to have to adjust here. It's a 5-prong test. We're going to take a look at each of these in a little more detail. But the difference between this one and the use variance, the applicant doesn't have to pass all of these for you to grant the area variance. In fact, the applicant could flunk all of them and you could still grant the area variance. As crazy as that seems, it is possible. So next slide, please. The first prong of that test is, will this application, if approved, will it change the neighborhood character? And would the undesirable changes be eliminated with any conditions that you might impose? So in this first picture in the bottom left, this again is downtown Albany. It's the commercial strip with some residential uses over the first floor retail. But in the far left, you see a high-rise building, a high-rise residential apartment building. So when this was being built and the board had to review this, do you think that, you know, a 25-story apartment building is creating a change to the essential character of this neighborhood? I think you would have to answer yes, because you're going from, you know, a human-scaled neighborhood to a multi-story commercial apartment use. But just because you're doing that, it doesn't mean that necessarily that you would have to deny the application. Maybe they're looking to the goals of their comprehensive plan that identified the need for multi-unit housing and in an urban setting like this. And that is the street where they wanted to start to drive that particular kind of development. So in that case, maybe it's not an entirely undesirable change. And what could they do with conditions to make that fit a little better into the neighborhood? Well, I walk by there all the time. I don't really think they've done a lot to make that fit into the neighborhood. There's no particular landscaping or pedestrian amenities that make it a better fit. In this case, it is what it is. In the middle picture, we have a parking lot. So is this changing the neighborhood character? Well, it already looks like it's a commercial strip with a lot of retail commercial uses here. And we thought this was a parking lot, but it's actually a used car parking lot. So pretend it's just a regular parking lot that was built there. I would say the character of the character was changed a little bit, because if someone was walking along that sidewalk, maybe they don't have a perceived sense of safety as a pedestrian the way they might have when it was storefronts rather than a parking lot. Because as you can see, those cars are really inching up there, and there's nothing that really says, hey, stop here. There's no fencing, there's no landscaping, there's nothing that really gives a sense of security or walkability or friendliness to that particular street. And to say nothing of the utility pole smack dab in the middle of the sidewalk, it's definitely impeding walkability and mobility there. So what could we change with conditions to make this application a little better? We could say that we want a particular type of landscaping and trees and maybe a decorative fence, something that would give a perceived sense of welcoming and security at the same time. And this last picture is just an example of signage. So, you know, maybe this application, when we first saw it, was an application for a digital sign, and you know, those are apartments right behind it. And so the review board said, well, can we do something to help this situation where the residents wouldn't be looking at a digital billboard, 24 hours a day with flashing messages and flashing gasoline prices. And so they found conditions that said, well, we want a lower type of sign with gooseneck lighting so that we don't have a lot of light pollution, and it's a carved wood-like sign, and it fits with the community character and the brick of this architecture a little better than a digital sign. So that's just an example of conditions that you could impose to make it a better application. Next slide. Are there any alternatives not requiring a variance? So again, this is where the board has to get really creative. It is your responsibility to ask this question. Not everybody is entitled to have a variance just because they're asking for one. So if you're a board, you could go do a site visit. If you're not familiar with the property, take a gander and say, oh, look, maybe they could put the driveway to the left instead of to the right, and they wouldn't need a variance at all. Or, maybe if we did this, or maybe if they considered that. It's your job to ask that question. But maybe the applicant has a really good reason for doing things the way they've presented them on the application. Maybe it had to do with money. Like maybe it's just more financially feasible to do it their way than the way that you're suggesting, or their way has a better view, or generally just better aesthetics. But again, it's up to you to make sure that you're asking, is there another way of doing this where we wouldn't have to give you a variance at all? And the third prong is the substantiality of the request. So the goal is to grant the minimum variance possible. So what is this applicant really asking of you? What is the magnitude of their request, or what is the amount of the variance that's being requested? The name of the game here is to really balance safe access, make sure what they're asking for, number one, is really safe above and beyond everything else. So 5 feet out of a 10-foot request is actually a 50% variance. So in terms of magnitude, a game of percentages, that's a pretty big request, even though it's just, a little bit in terms of feet and inches. But that is up to you to decide. Again, you can also do this by doing a site visit and seeing with your own eyes and walking around the site, making your own determinations if what they're asking for is really overkill. Is it too much? Do they really need to have this entire request, or can we trim it back and still have a good project that is balancing health, safety, general welfare, and importantly, aesthetics? That's one of the questions that you should be regulating for as well. And the fourth prong, next slide, are there any physical or environmental impacts that may happen as a result of your granting this area variance? So the environment is not just your flora and fauna, it's all kinds of other stuff. It's economic health and vitality, it's physical health, it's sunlight, it's wind, it's smells, it's all kinds of things that you might not even consider ordinarily. Some examples would be, if you granted this area variance, are you creating a blocked view for the neighbors? If you grant the variance, it might be great for this applicant, but are you creating a drainage problem for the adjacent parcels? Are you impacting any wetlands? If you go through with this area variance, are you taking parking spaces off of the street or out of that particular area? So you could be helping one person when you give them a driveway or a drive-through, but in reality, you are taking parking spaces off of the street because, nobody can park 5 feet in front of the entrance or 5 feet on the other side of the entrance. So you could be making matters worse, even though you're helping that one particular applicant. Another impact that you might be reviewing has to do with solar applications. So if you allow somebody to have an area variance, maybe to increase density, will you be blocking someone else's ability to get sunlight on their solar panels? So there are all kinds of environmental and physical impacts that may occur when you grant an area variance. And finally, the last prong of our test is, here's this self-created situation again. And unlike the use variance, even though the situation is self-created, that may not preclude you from granting the area variance. So in a lot of these older neighborhoods, they have sheds and garages before the existence of the local zoning. So if they wanted to expand that, or maybe they were relying on someone else's plans, like an architect's plans or an engineer's plans that were flawed, and they didn't know that. They just assumed because it was someone with a professional license that the plans were accurate, but it turns out that there was a mistake. That would not be considered a self-created situation where you would preclude them from getting a variance. It really was no fault of their own that they relied on someone else's certifications or drawings. So again, next slide, please. all of those 5-prong tests, you know, anybody can fail all of them, or they can flunk just one of them and still get the area variance, especially because you can impose conditions that might ameliorate a bad situation and turn the project into one that you can actually live with, or one that, you know, even better, might be a beneficial project. So conditions should always be very clearly specified and in your meeting minutes and in your application. And the conditions have to be reasonably related to the impact of the proposal being considered. So what that means is you can't ask for park benches across the street when you really are trying to make pedestrian amenities better on the other side of the street. So you have to ask for things on the parcel or directly near the parcel. And there's got to be a nexus. There has to be that connection between what you're asking for on the land and the condition that would mitigate anything negative should you grant the area variance. And, you know, for example, these conditions, it's not enough to say we require a fence. You should say why you require the fence. We require a fence to shield the view, and it needs to be a solid fence. And that way, in years down the road, when the fence falls apart or rots or burns down, or who knows what could happen to that fence, it needs to be replaced with a similar style fence. So you just can't replace it with a chain link fence if the idea is to shield the view, because even though the chain link provides an enclosure and some safety, you can see right through it. So it's not mitigating or offsetting the negative impact that you were trying to shield when you offered the area variance. Next slide. And as I said before, it is your job to grant the minimum variance that is necessary. Just because somebody is asking for 25 feet, you know, you don't have to give them the whole kit and caboodle. You could say, we believe that 12 feet is more than enough to meet the goals of this application. And that's about it that I have to say. Chris, did I miss anything?
I don't think so, Trish. Great.
Okay.
Thank you. So we'll talk about some procedures now, and we'll start with board rules of procedure. And these are for boards. We have some sample boards of procedure if you don't have any yourselves. And I feel like many boards do have rules of procedure because we haven't had requests for them lately. We used to, there was a time when we'd present this slide and then we'd get a wave of requests for sample rules of procedure, but we haven't had any lately. So maybe most boards do have this now. But what isn't covered by your zoning regulations, what isn't the details of the roles of different board members, the roles of the chair, and maybe there are other officers, a vice chair and a secretary, maybe even a treasurer. The format, the rules for calling meetings and circulating agendas, who puts them on the website and who posts them, how you take public input at meetings, not hearings, for example, and how the minutes are handled, how referrals to the county planning agency, what is the procedure. These are all details of the process that might not be in your zoning regulation, and they are appropriate in board rules of procedure, which are very helpful, for example, when a long-term chair might be absent and the others have to run the meeting without the chair. So just available if you need them from us, and I'm sure you can You can find them out there or update the ones that you have. This is a quick slide, fortunately, for Zoning Board of Appeals overview, because a lot of what comes before the Zoning Board of Appeals is type 2 in nature. They're type 2 actions. Interpretations, minor area variances are type 2 actions. If the Zoning Board of Appeals is doing special use permits, that might be another story. You might get an unlisted action or two, even a type 1 potentially. But a lot of the time, the Zoning Board of Appeals is an involved agency. There might be relief associated needed as part of a larger project in which the planning board is the lead agency. So the Zoning Board of Appeals would be an involved agency. So I'm not going to say any more about this, except that we have a publication that you see on this site. We have an online interactive course on Seeker Basics, and we offer Seeker Basics as a 2-hour course to live either in real time on WebEx or Zoom, or in person when we hope to be back to presenting in person, and a course where we go through the EAF, the short EAF. We have a hypothetical project. Open meetings. Every convening of a quorum, a majority of a board that has binding decision-making authority is subject to open meetings law. And a work session, like an agenda session, if you meet briefly just to discuss the applications, which is a good idea. My boards, when I was a municipal planner, the boards I staffed did this. They just went over the application quickly to be sure that everybody understood what was being requested. Or a site visit, certainly a good idea. If a quorum of the board gathers and plans on discussing the merits of the application, you shouldn't be discussing the merits of the application outside of your regular meeting. But if you can all gather on site, there's a case that said this is allowed. If you gather for a site visit in a quorum and only gather information, that's not subject to open meetings law, but it's a lot easier to avoid any questions if you make the site visit in groups of less than a quorum. You should notice the media of all your regular meetings, post them in a conspicuous place and on your website. That's old news now, but there's new news, and that is that if you, and maybe this is more appropriate for the next slide, your Zoning Board of Appeals should almost never have to go into executive session. But if you do have to consult with your attorney, that's attorney-client privilege. And I'm not going to go on about executive sessions because we go on about that in other courses, conducting meetings and hearings notably, and we're getting a little short on time. So records should be, and this is relatively new, records scheduled for discussion at an open meeting must be available for public review on an agency's website in advance, to the extent practicable, as open meetings law reads. So if you're a really rural, small municipality that doesn't have the ability to do this, you should provide copies of these records, the application materials and agendas at the meeting itself. And add to that notice of meetings that are scheduled less than a week in advance. It used to be to the extent practicable. Now it's at least 24 hours before the meeting. So if you schedule a special meeting 2 days from now, you've got to get notice out 24 hours before that meeting and get those, get the information about that meeting up as soon as possible, 24 hours in advance. And I'll leave it there for that slide. The state hearing notice requirements, all the same as those for public meetings. Oh, and I think this is Trish's. Sorry if I'm stepping on your toes here, Trish. Back to you.
That's okay. I'll pick up where you left off. You need to post notice in your legal notice in an official newspaper. Every municipality should have a designated official newspaper. It has to be one of general circulation and a paid subscription. It can't be a freebie. And you have to post that notice 5 days prior to the hearing date. And mail a notice to all of the parties in the appeal and to regional state park commissions if they're 500 feet from a state park or parkway, and certain other agencies. The content should include the date, the time, the place, the nature of the proposed action, and the location of the subject property if it's applicable. Next slide, please. Okay, and here's the best example, post a notice so everybody could see it. You can adopt additional local noticing requirements, such as posting a sign on the property. This seems to be the best practice. Everyone can see it. Mailings to the neighbors, and you can put a notice out on your electronic bulletin board or your listserv. And mailing to the neighbor is another good one. Don't only rely on mailing to the owners. They could be out-of-state owners or non-resident owners, and the actual people that live there won't be getting the notice. So next slide, please. The hearing notice. Sometimes if the applicant is looking for an interpretation, this is a tip. So when the decision on the interpretation dictates if a variance will be required, include language in case the interpretation isn't in the applicant's favor, that the hearing can proceed. So they won't have to come back the next month for a completely separate public hearing. So in this example, the applicant requests an interpretation for a proposed single family dwelling if it complies with the setback. And then it says the applicant also requests a variance from the setback in the event the ZBA determines the dwelling's location does not comply with the 60-foot setback. So that's a really good way of keeping that application moving. Next slide. 239NN, this is known as be a nice neighbor or notify the adjacent municipality if you have a special use permit or a use variance that's within 500 feet of an adjacent municipality. All you have to do is send them notice. You don't have to wait for a response. And note that you completed this task in your application file and in your meeting minutes. Next slide. And 239M, I like to remember the M for mandatory county review. This applies to applications if they are within 500 feet of a municipal boundary of a state or county park, highway, stream, or institution like a prison or a university, land on which a state or county building is located. And this includes buildings like storage sheds and garages, and farm operations in state agricultural districts. There's an exception to this, and area variances are exempted. And we recommend that you ask your county or your municipality for a map and to shade in that 500-foot boundary. So it's pretty easy for you to take a quick look and see if you're going to trigger that 239 mandatory county referral. And the county takes a larger, more regional look at your application, whereas you're taking more of a micro look at your application. And also, they have professional planning staff, and you can avail yourself of their services that you might not have at the local level. So don't forget to do county referral. If you skip this step and you're later challenged, your whole application could be overturned. So don't screw up on the county referral. Next slide, Chris.
Right, Trish, the not referring the application to the county properly or taking votes before you hear back from the county is the easiest way to have your decision challenged and invalidated. And it's not in your jurisdiction to take final action until you receive the county planning agency's report, the referral, or 30 days have passed after the county has received the full statement. Now, the 2-day rule is for applications that the county has had, when the county has had the full statement for more than 30 days, but the local board meets and gets the report back to you at least 2 days before you have your review. So if the county has it for 35 days and for whatever reason you're meeting 38 days after the county received the full statement, even though the county missed that 30-day deadline, it still got to you before at least 2 days before your meeting. So the statement, the referral that the county made is binding. And of course, you can extend that time by mutual agreement. But what happens when the county receives the referral? The county can say, as it often does, it's a local decision, no countywide or intermunicipal impact, or and can give informal recommendations. But the county can also recommend, and the county can also recommend approval. But if the county recommends disapproval or approval with some modification, and the local board wants to override that recommendation, that referral, the local board has to vote in a majority +1 and describe in the record and send a report of the final action to the county planning agency about why the local board voted contrary to the county's recommendation. And it's good practice to share the minutes with the county anyway. That can be part of the report of the final action. The taking action, the actions only, the board can only move when the motion or resolution passes with a majority of the entire board, the fully constituted board. So if you're you have one vacant seat and somebody's missing on a 5-member board, and 2 of the members of that board agree, pass, vote yes for an area variance, and 1 votes no, that's 2 is a majority of those present, but not a majority of the fully constituted board. And so that motion would fail. And it's a default denial when the motion fails for zoning boards of appeals. If you are acting, if the zoning board of appeals is acting in its original jurisdiction, such as in a special use permit application, that failure is the equivalent of no action. The motion failure is no action, but it's a default denial for appeals. And the if within 62 days, the board convenes again and votes again, there's a new member on the board, let's say all 5 members are there. The same 2 vote for it, the same 1 votes against it, but the new person and the one who was absent at the last meeting votes in favor of the relief. The that default denial can be reversed. So those additional votes can be taken within 62 days after the close of the hearing, and that won't trigger the rehearing process. Now, the rehearing process is a really kind of unusual opportunity for the Zoning Board of Appeals to reconsider a matter it previously acted on. It's a way to take away, it's a means of removing a variance that it might have granted before. But the matter can't have been reheard before, and this section of statute is at the end of permitted actions by the Zoning Board of Appeals, the section permitted action by the Zoning Board of Appeals. And your handout that I think Jason forwarded to everyone does include attachments to the slides, and Town Law 267 is there. So the statute that pertains to zoning boards of appeals, and the Zoning Board of Appeals can vote to reconsider a matter it acted on already if it has not been reheard, and if the motion to rehear the matter receives a unanimous vote of all present. So not everybody has to be there, but everybody there has to vote, yes, we will rehear this. And then at the next hearing, when they set the hearing, they all members, all those in attendance have to vote unanimously to change the earlier decision. And it's usually for the removal of a variance, removal of that relief. They might have realized that they shouldn't have granted it. And they can only do this if the applicant hasn't acted in good faith on their earlier decision. So if they granted an area variance and the owner started building, the ZBA can't take it away. If vested rights have been established, then that variance cannot be rescinded. So Trish is going to wrap up and talk about decisions, findings, and filing.
All right, thank you. So yeah, we're wrapping it up here. This is about tying up your application and making a good decision that's gonna stand up if challenged. So next slide, please. All right, your decision has to be made within 62 days after the hearing closes. So you can hold a hearing open for a while, but as soon as it officially closes, that clock starts ticking, and you only have 62 days to decide if you're going to move forward or not. The minutes have to contain a record of each vote. There's no anonymous voting. So the bare bones minute taking would include the motion, who voted, and how they voted. And you need to include the language of the motion and any conditions that were passed. Again, those conditions need to be directly related to the property, and they need to be clearly spelled out so that they can be enforced in the future. And send a copy with those findings to the applicant and to the county if applicable. And findings, the findings is connecting all the dots. It's your analysis that applies the law to the facts of the application and everything that you read and interpreted and led you to a conclusion. So it should describe why you did or why you did not approve an application. And it's also going to include reasons why any conditions were imposed. And your findings should be able to support a decision if challenged in court. If you use conclusory statements like the applicant failed the test or the application was denied, those are conclusory statements. They may be accurate, but they really didn't give the court or anyone else any indication as to why you imposed your conditions. There's just no detail or justification in what you said. And your findings should be approved by your board and not simply drafted by your attorney and filed. And we do have a sample decision document in our publications. We're happy to send that to you. And next slide, please. And finally, your filing. And everybody needs to know what this phrase under the municipal clerk's control means, because what the filing is considered, the clock again starts ticking when the records are placed under the municipal clerk's control. In some municipalities, that means putting it directly in their hands or directly in their in basket. In other places, it means that they have to date stamp it. And you can see where this could get tricky because not every municipality keeps full-time hours. Sometimes, you know, they're only open a day or two a week. So when do they finally, when does the clerk actually get their hands on that application to deem it complete and under their control? And you have to file that decision within 5 business days after the decision is rendered or sooner. Notice those are business days and not calendar days. If you're using a checklist or a timeline, it would be clear to the applicant and to the review board what those days are. You know, those distinctions are different all over New York State statute, whether it's a business day or a calendar day. And it's important because once something is technically filed, it starts the day of that 30-day appeal period for the applicant or an aggrieved party to commence a certiorari, which is an Article 78. Effectively, they are suing the municipality. And you want to make sure that you don't leave that window of opportunity open for anyone to bring an appeal. So the sooner that you can shut that and inhibit anyone from trying that, the better. So next slide. And this is our contact information. Chris, do you have anything else to add as we wrap up?
No, I don't think I do, except that our website was redesigned. So if you used it frequently in years past and you're not able to find something, let us know. You can send us an email to the general email address or give us a call at our general number on the screen. We're still working sometimes remotely, especially when we're doing webinars, because those are hard to do in our cubicles in our office. But there is usually somebody at the office who can take your call, and we all respond to our emails. So Jason, do you have any other questions that might have come in? And sorry, we're about it. We're a couple minutes after 8, but we can answer some last minute questions if there are any.
That's quite all right. We started a few minutes late, and I don't think any more came in the chat room, but I put a few messages in there with some great resources on the DOS website, and then my contact information as well. So folks, if they want to get in touch with me, please do so. Also, I know it's past 8. I'm happy to hang out for a few minutes if people have questions, otherwise, you are free to go. Thank you so much for joining us tonight. And a big thank you to Chris and Trish from the Department of State for doing this excellent presentation. So thank you very much.
Thank you, Jason, and you're welcome. And
Thank you.
I will see you tomorrow.
Yes. So tomorrow for folks, maybe we'll see some of you folks tomorrow on the site plan review webinar. And
we'll log on same time, and we'll talk about our plan. So we'll talk to you then, Jason.
Very good.
Good night, everyone.
Good night.
Bye.
And yes, Elaine, you had a question. Tomorrow is the webinar on site plan review. I believe it starts at the same time at 6 p.m. And so you can register for that right up until 5 p.m. Up to an hour before the session starts. And I apologize for my spooky appearance, but I am in a Monroe County office building, and they turn the lights out at about 7:45 every night. So, so it's seasonally appropriate here to tell zoning ghost stories.
Yeah, right. Well, seeing no one with any last minute questions, I'm going to log out, Jason, but if anything comes up, you know where to find me. And I'll
That's
talk to you
fine,
tomorrow.
Chris. Thank you so much.
Okay, you're welcome. Good night.
Good night.